Hi, I want to discuss this issue of a policy manual the company has and whether that creates a contractual term between the parties. So, a little bit of fundamental contract analysis. To create a valid contract, there has to be offer, acceptance of that offer, the material terms are agreed, and there must be consideration provided from one party to the other. So usually when the agreement is being made, the consideration that the value given by the employer is a promise to hire you at an agreed wage, etc., and the employee promises to provide his or her services to do the job as described. Those are the fundamentals. And very often the issue with the policy manual is whether there's consideration for a term in the manual. So big picture is there's a big difference between a policy manual that sets workplace standards, such as these are the hours of work, this is the expected code of conduct, these blah, blah, blah. Just the usual day-to-day terms in the manual, as opposed to creating a substantive legal right. For example, if the policy manual defines this is what happens when you're fired, this is how much we're going to pay you in severance when you're fired, that creates a substantive term. So the policy manual then needs consideration, the usual contract analysis, but the big thing is usually consideration. So if you show up to work and you start working, you haven't seen the policy manual, and all of a sudden 2 weeks later, the boss says, oh, by the way, here's the policy manual, be familiar with it, because if you're fired or whatever, this is what you're going to get. So if that manual was not part of the initial terms of employment, it's unlikely to be an enforceable term because there's no consideration to support it. So other examples of things that the company very often sticks in a policy manual are things like the right to move. Well, that won't be that'll be a substantive term. It needs consideration, the contract test. Or there may be a non-competition covenant in the policy manual. Again, same issue. It's unlikely to be enforced. So generally speaking, if the policy manual deals with substantive issues, then it's going to need to pass the test of contract formulation, and there must be independent consideration for it. So if the employer said one day, oh, by the way, here's our new policy manual, I'd like you to accept these terms, and there's a substantive term in it, like a non-compete or a severance provision or something important that's a change in the legal obligation, and the employer says, please sign this, I'm going to give you a raise of $5,000 in consideration of you accepting this, then there's a contract. If there's nothing given, then it's very unlikely to be a contract. Another example in a real life case is the employer handbook said, if you're absent for more than 3 consecutive days and you don't call in, then we treat that as a termination and you have no rights on termination. Or there could be a contract, a policy manual that says we have the right to suspend you without pay during an investigation. Again, that's a substantive change and will not be enforced. So those are the basic rules. If you have an issue like that, be careful with it and get legal advice. So be smart and beware.